Hi, this is Erica Merrill. I'm the founder of Perfect Legal Video, and I am very excited to bring to you today a panel discussion on how divorce and bankruptcy kind of go hand in hand sometimes, and to answer some of the questions around when that happens. And I have with us today attorney Tim Stickradt. He's out of Detroit. He owns a bankruptcy law firm with his wife, Peggy Hammerschmidt, and they are, they are right in the center of Detroit and in the outskirts as well. And also, we have with us today Amy Ruby at Ruby Legal Solutions, and she owns a family law firm out of the Detroit area as well. So, welcome, Tim, and welcome, Amy.
Hello.
Hello, thank you, Erica.
Thank you so much for joining us. So today we're going to be talking about the complications of what happens when you're going to get a divorce and you may or may not need to file for bankruptcy. So let's start with the question of, should you file for bankruptcy before the divorce or after the divorce? Let's start with Amy because she's a new guest to the show.
Hi, good afternoon. The bankruptcy process and the divorce process do go hand in hand occasionally. If you are considering filing for bankruptcy and you have already started the divorce process, certainly the process that we take here is to contact a bankruptcy specialist like Tim and Peggy and discuss that matter with them. It depends on what types of assets and liabilities you have, what your debt picture looks like, and there are some benefits to filing and taking care of those things before the divorce is filed. So if a new potential client comes to my office and is considering filing for divorce, one of my interview questions is to go through the assets and liabilities that the parties own and look at the things that they owe. And then if they're in a situation where bankruptcy looks like an option, perhaps we could then contact someone like HS&A and ask them for input about what decision is best for these people. If they do have already filed for divorce and subsequently file for a bankruptcy, their divorce is then put on hold. So that is something to consider.
Okay, thank you so much. That's a great answer. And then, Tim, what would you add to what Amy just said?
Yeah, well, first of all, I agree that these two things do go hand in hand oftentimes. And if you're even considering the possibility of either, you should talk to an attorney about that particular area of law. I found that a lot of times I don't know the answer to divorce questions, and many of the family law attorneys that I talk to don't really know the nuances of bankruptcy law either. So if you're in a situation where you are definitely going through the divorce and you feel like you may have some financial issues, though you're not certain what to do about that, I think it's almost always the best advice to talk to a bankruptcy specialist, talk to a divorce specialist, get them on the same page, have them talk to one another. You want to protect yourself. Usually bankruptcy and divorce aren't, most of the time, they're not something that just jump up at you and surprise you out of nowhere. Usually there's some buildup to it. It may be subtle, but you can usually sort of see things coming. So it's always good to look farther down the road, get some advice, start planning ahead of time. You may not need to file bankruptcy after a divorce. You may decide not to divorce and still do bankruptcy, but it's always important to just get the roadmap out in front of you laid out before you make any decisions.
That's really great, and thank you so much for that information. So if we are considering filing for bankruptcy, and Tim, I'm going to be asking you this question first. I'd like to know, is it more beneficial to file for bankruptcy as a couple, or should you do it individually?
That's a great question. I think it always depends. When you go into when I have a client consult me about a bankruptcy issue and they're talking about divorce, one thing I will mention is that when you're getting a divorce, you're usually dealing with a few different issues. You're dealing with the division of assets, the division of debts, and sometimes in cases of minor children, you're dealing with child support and custody orders and that sort of thing. And if you can take one of those issues out of play, for example, the debts, by doing a bankruptcy before the divorce, well, then when you go into the divorce, if you can do it as a couple, you can do the bankruptcy first. Then when you go into the divorce, you don't have that issue to resolve. Plus, if you do the bankruptcy before the divorce, I mean, you're going to spend half the money, because if you both have to do the bankruptcy anyway, at least where we're concerned, we don't charge more money for a joint bankruptcy than we do for an individual one. So if you can file jointly, pay one fee, then go divorce, you save some money there as well.
Wow, I hadn't even thought of it that way. That's a really good point that you made, Tim. What would you like to add to this answer to this question, Amy?
I don't really have much to add, other than if someone comes to me with a similar question, my kind of first step is to have them contact a bankruptcy attorney, because if they're already in the throes of the divorce, now we have to stop the divorce process. And as Tim mentioned, there's typically if the parties have been married for an extensive period of time, of course, they have a lot of joint debt, or they co-signed, or there's other things and nuances where it's really beneficial to the couple as a whole to, like Tim said, take that out of the mix. There's already enough in a divorce to separate, especially if there's children. You have custody, parenting time, child support, potentially spousal support. You have any sort of retirement accounts. You have the property settlement of the actual assets that they do still are able to maintain, which can include a house, rental properties, vehicles, intangible assets like stocks and bonds, all those kinds of things, businesses. There's just a lot to sort out. So as to mention, if you can take one of those prongs out of the mix, I think it helps really alleviate the tension. And a lot of times, of course, people are divorcing due to financial concerns. So sometimes that resolves that issue. And as to mention, sometimes maybe people don't get divorced after they solve that part of the problem.
Yeah, and if I could add one thing, Erica, I think another thing you have to ask yourself is how amicable is the situation? So there are divorces where the people literally can't talk to one another, can't be in the same room. And then there are other situations where people come in, know they're going to do this. They just don't want the marriage anymore, but they're good otherwise. They want to remain friends. And so in those cases, it's usually easier to proceed and do a joint bankruptcy. Also, there are certain circumstances where there could be a conflict of interest on the attorney's side, where if two people come in and the bankruptcy might result in more harm to one party than the other as you look forward into the divorce. I mean, at that point, I would advise people not only to do a separate bankruptcy, but to also go talk to separate attorneys, because, I could be compromised due to that conflict. So that's just something to consider. And I kind of take that on a case-by-case basis. I kind of feel that out, as I meet with the client.
Yeah, it's very tricky too, because sometimes you start off down the path and it's kind of it's not contentious, and then something happens and during the divorce that really upsets one of the parties, and then all of a sudden nobody's talking anymore. So yeah, and I agree with you that it's really, you've got to look at what the mood is and what the couple is going through and how they are together to decide whether they can do something amicable like this. Now I know, Amy, you just wanted to add something to that.
If I could, Tim brought up a good point about being able to handle a joint bankruptcy filing. And I just wanted to point out, this is something that I do get asked quite often, is can we use the same attorney to get divorced? And the answer to the question is no, you cannot use the same attorney. The answer also to the question is that you can use one attorney, but the one attorney represents one of the parties. So there can be one attorney involved in the divorce process, but that attorney represents one of the parties and the other party is not represented. And I think sometimes that gets a little bit confusing for people. So whoever comes to speak to me, that is the person that I would then be representing. I do not represent the other spouse in the divorce process, because you are conflicted. You cannot represent two parties on the opposite side of the V in an adversarial case.
So the question then is, do you have two bankruptcy attorneys?
Sometimes you do. And, ordinarily under circumstances where we're not talking divorce, I would usually prefer a couple who's considering bankruptcy, or maybe even just one of the parties is considering it, but I would prefer them to come in together and consult with me. On the contrary, though, when there's discussions of divorce, I would actually prefer that only one of the parties come to me first, tell me what's going on, then I can advise them freely. And if it turns out, based on what they say, that maybe we could do a joint bankruptcy, then we could bring the other party in and do that. But there are times when the advice I give just directly competes with the other side's interest, and there's just no way for one person to do a bankruptcy. So we would refer, I would give them some names of other attorneys to go talk to, before that they go forward, because there is an inherent conflict of interest there that's always looming.
That's a really good point. I mean, the conflict of interest is, it's really good to make sure that you stay out of that little trap. Those are all very good points. So Tim, I had a question for you about divorces being stayed because of a bankruptcy. And when you answer this question, if you could also talk about just the definition of an automatic stay and how it works, in conjunction with a divorce and filing for bankruptcy.
Sure. So first of all, when you're using the word stay, it simply means stop, okay? And to break that down a little better, when you file for divorce, you're filing in state court pursuant to the state laws of whatever state you reside in. When you're filing bankruptcy, you're filing pursuant to federal law. Generally speaking, federal law trumps state law. So that is to say, if you're in a divorce, the divorce has already been filed, you're halfway through or wherever you are along the way, and you're going along, and one of the parties to the divorce, doesn't matter who or both, files bankruptcy. Right? The bankruptcy law there's a provision in the law called the automatic stay provision, which means that everything in state court that's going on right now is stopped. So that includes your divorce. So if you're going through your divorce, one of the parties files bankruptcy, the divorce gets put on hold sort of indefinitely, either until the bankruptcy concludes or until the parties convince the bankruptcy judge that it's okay to pursue the divorce in spite of the stay. So the stay would still pertain to everything but the divorce, if that makes sense. And sometimes that's necessary. I'll give you a situation that's fairly common. You're cruising along in your divorce and one of the parties gets hit with a garnishment, right? Someone comes in and sues them and goes after their paycheck and starts to garnish money. Well, that's one of the things we call bankruptcy emergencies. Like that's where I take that case and put it to the top of my to-do list. And so we'll file that bankruptcy really without asking questions. And it doesn't make a lot of people in Amy's shoes happy. I'll get a phone call usually a day or two later from the other divorce attorney like, come on, man, what the hell? What are you doing here? And I have to explain to them, listen, I've got to protect my client. She's my client. There was a garnishment. I had to file the bankruptcy. We have no objection with you guys going forward in the divorce, but we've got to convince the bankruptcy judge that that's okay. So it can be a hiccup. It can be a delay. It's not good for someone who just wants to get through their divorce, but that's just the way it goes. When we file a bankruptcy, that's one of the byproducts of it.
Oh, absolutely. So for you, Amy, I know that when we were preparing for this discussion today, you had brought up a really interesting point about a new development in the assets and liabilities disclosure in 2020. Could you expand on that a little bit?
Sure. The State Court Administrative Office issued a new standardized form effective January 1st, 2020. And it's called a Domestic Relations Verified Financial Information Form. It's a form that's approximately 8 to 10 pages. It asks about your personal information, employment, income information, your assets, which include real property, financial accounts, pensions, other retirement accounts, life insurance, vehicles, personal property. It asks various questions if anybody's holding any money for you, if you have business interests, and then of course debts. So it really tries to tie in all of the assets and liabilities of the parties to make sure that everything's being put out on the table so that we can discuss it, determine how we're going to separate that Obviously, on the bankruptcy side of things, they certainly go through a very similar set of questions, asking what types of assets and liabilities are going to be brought up in the bankruptcy. So it's something that's really helpful to make sure that we are considering everything that the parties have. And it even includes things that are considered separate property. In a divorce, some things can be considered separate versus marital, and that distinction is important. But we do need to bring everything to the table before we can decide how it's going to be distributed to make an equitable division in the divorce.
Absolutely. Now, Tim, I would love if you have anything to add to that, to let me know. And is there anything else you'd like to add?
Yes, in fact. One thing to remember when it comes to filling out forms like this is you've got to be honest with this stuff. You can't try and hide things, because that never works out. It will always be uncovered. This form that Amy refers to, I don't know much or anything about it really, but there's a similar set of questions that have to be answered under penalty of perjury in a bankruptcy. When you file a bankruptcy case, you have to disclose all of your assets, all of your debts. And many of those things are discoverable outside of just the form you fill out. There are records of ownership of assets and bank accounts and cars and real estate, and all that stuff can be found out. And I was just thinking as Amy was speaking that, I don't know, if I were a divorce attorney and I was in a contentious divorce and the other party had filed bankruptcy, I would certainly want to go back and look at the bankruptcy documents and the disclosures that they filled out and compare them to what's on this, is it DRVIF? I wrote it down as you were saying it, this form, and vice versa. I think like a smart bankruptcy trustee might go after and look at if they can discover this form that the person filed before they filed bankruptcy, just to compare to make sure that they're not hiding assets. I mean, all that stuff, that information's out there, and the more times you have to disclose things, you have to remember that someone's going to see that. And a lot of times, I have clients that I have to coax information out of, and it's just important to remember, you've got to tell the truth. You've got to be complete and honest when you enter into these things.
Absolutely. I think that is so important, because like the last thing you want is to, be charged with a crime for lying. And I mean, it is possible that you can be charged for a crime later, right?
Mm-hmm.
Sure.
Okay. So yeah, that's the last thing you want. And you do hear about all kinds of shenanigans in that area when you're talking about divorce, and it can get pretty nasty, and people want to hold on to things, so they try to hide it, and then really comes back to bite them in the butt. So let's talk about what is dischargeable, because I know that that's one of the questions that comes up, and when you're going through a divorce, it might also complicate things a little bit if you're timing on the divorce and you get an asset and then it's discharged, maybe it's not fair to the other party. I'm not sure how all that works, but that's why we have you on here. Who wants to go first with this? Okay, Tim, you got it.
Okay. Well, this is where the strategy is important. When I have a bankruptcy client who's going through a divorce, or maybe they're about to file a bankruptcy, maybe they've already filed one, I always, whenever possible, will talk to their divorce counsel if they're structuring a divorce settlement. One thing you want to try to avoid in divorce is signing up to take on other debts that you don't necessarily have to pay for. What I mean by that is, two people are getting divorced. Let's just say they have joint credit card debt. If you're contemplating bankruptcy or have gone through well, if you've gone through it, you don't have that issue. But if you're contemplating bankruptcy, what you don't want to do is negotiate something where you're required to pay your spouse's debts, or you're required to pay all of the joint debts. Because if you do that and then you go to file bankruptcy, even though your discharge eliminates your obligation to the bank, the divorce judgment obligates you to still pay for the debts on behalf of your former spouse. And you can't get rid of that in bankruptcy. Your obligation to pay something pursuant to a divorce judgment, you're stuck with that. So if you can negotiate another way and get around agreeing to pay for the joint credit cards or to pay for your spouse's credit cards, take advantage of that if you're contemplating bankruptcy, because you're just going to put yourself in a spot where bankruptcy is not going to help you. And just a couple other things to keep in mind. There are some, and I think it probably goes without saying, but I'll say it anyway, certain debts that are incurred through a divorce. The biggest two that come to mind are child support and spousal support or alimony. Those are non-dischargeable, at all in bankruptcy. You cannot get rid of those anyway. So when you agree to those, and some of that stuff I believe that Amy will tell you is formulaic to an extent based on income and parenting time and all that, but that you cannot get rid of. But just be careful and be cautious. If you can have your bankruptcy attorney communicating with your divorce attorney, you're probably in pretty good hands.
That's really great to know. I'd love to give Amy a chance to chime in.
Yes, thank you. Certainly, the child support and spousal support are the non-dischargeable issues when it comes to bankruptcy. So I get that question, perhaps if I represent an individual who thinks that the spouse that's going to have to pay them the child support and spousal support says, well, what happens if after we get divorced, they file bankruptcy? And the reassuring part of that is they cannot discharge the child support and spousal support obligations in bankruptcy. So the child support is formulaic, it's very complicated, and we have this masterful calculation online where you input the information and it spits out a number. The 5 major pieces of that include the 2 different income sources from each of the parents, the overnights for the child, and then the other 2 big things are the cost of the health care that's paid and if there's any daycare costs. Those are the main contributions and factors that input into the child support formula. That indicates a monthly payment amount, and that's pretty much what it is. There's some fluctuation and some negotiation. You can deviate if you follow certain protocols and court rules. The spousal support is a bit more negotiable. It's a property settlement term, and there are programs that will calculate a number, but those are much more flexible and negotiable as opposed to the child support figures. But as it relates to the bankruptcy specifically, those are the 2 deals that are not going to go away even if you do file for bankruptcy after the divorce is finalized. And I do wholeheartedly agree with Tim on the idea of the property settlement. You don't want to sign up for something that ultimately could have gone away or really did go away. But if you agree to pay it, that judgment is pretty ironclad. It's very, very difficult to set aside, especially a consent judgment or make any sort of modification to a judgment of divorce. We ask lots of questions as lawyers in family court about, do you understand the terms of this agreement? Do you understand it's final, full, and binding? And it's really tough. So you really want to be mindful of what you're agreeing to. So it's important if there is a bankruptcy, even really being considered, that you counsel your parties to discuss it with an attorney.
That's really great to hear, and a good thing to watch out for. Now, one of the last things I'd like to talk about, and then we can of course add anything else that you think that we've missed at the end. But everyone knows people that have gotten divorced. Not everyone knows people that are going bankrupt, because a lot of times people keep that quiet. So that's why you don't hear a lot of the things that happen on that side. So I'm excited to have Tim add to this discussion. But when people are going through a divorce, as you've mentioned several times, a lot of times one of the reasons is financial, and people's credit are getting ruined. And then when they divide the assets, they have to, that party is going to have to refinance, whether it's a car or a house or whatever else that they financed. And, it might be challenging if they've ruined their credit. So what are some of the gotchas that we need to know about, and advice that you can give us when it comes to refinancing assets and when you're going through a divorce or after the divorce is over? We'll start with Amy, and then we'll have Tim come in on this.
I'm not sure where you want me to go with this. Sorry.
Okay. We can start with Tim and Amy. Okay. So we're going to start with Tim, and then we'll let Amy chime in if she has anything to add. Go ahead, Tim.
Yeah, so I think, again, it ties back to the bigger picture. and that is to get your ducks in a row before you just go off and do something. You really want to consult with the bankruptcy lawyer and the divorce lawyer and get them in sync on this. Because when you're talking about credit and divorce, I know that, and again, I'm speaking out of school, Amy, you can jump in here anytime, but when you go through a divorce, oftentimes part of the negotiation is, over real estate assets or vehicles. And sometimes I've seen this in divorce judgments where one of the parties gets the asset, but they have to refinance and get the other person's name off of the mortgage or the loan within a certain period of time. And it seems to me, in retrospect, when I look at these things and I'm consulting with a person who's got all kinds of debt issues, that it was never contemplated that when they agreed to refinance their house, for example, in 6 months, that, to do so, they'd have to have a certain minimum credit score to qualify for that financing. So it's important to consider that when you're looking down the road at, agreeing to refinance something through a court order. Because if you could put yourself really behind the 8 ball there by agreeing to do something within a time period, but not having the goods to do it. In other words, the credit score. So there's different components. In the past, we've talked about how we can build a credit score quickly after a bankruptcy. Maybe this conversation goes way, 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 way back a few months or a year, and we decide, well, let's do the bankruptcy now. So when the shit hits the fan, we can do the divorce, agree to refinance whatever it is, and go through with it. Do the bankruptcy. Did I say that backwards? Then do the divorce, then refinance it. So thinking about, okay, where's my credit score going to be in 6 months or a year? And maybe it's better to wait on the bankruptcy because maybe your credit score is decent now, but filing it initially might knock it down a few points. Just something to keep in mind. And again, a good reason to have your bankruptcy attorney and your divorce attorney on the same page.
That's very good advice and a good thing to think about, because what is the use of dividing up assets if when you get your asset from the divorce, you can't refinance it and keep it? It seems like you're doing all that work for nothing. So that's really great to know. Amy, is there anything that you'd like to add to this?
Yeah, I just add a couple of things. It becomes a bit difficult in the negotiations. I actually just had a mediation last week where this same thing came up, where we were trying to allow a certain amount of time. It's not unreasonable when you understand the bankruptcy and the credit score side of things to ask for 12 to 24 months when you're looking at it from a property settlement side of things. In a divorce, the party who's being released from the liability doesn't want to wait a year to 2 years for their credit to be released. So it becomes a bit difficult in the negotiations for the divorce to convince the side whose credit's going to be tied up, so to speak, to allow that to take place. But they have to recognize that it takes some time. One thing that I think is important, it does happen frequently, is you have a spouse who was the wage earner and they end up being into a position where they are paying spousal support. Now, if the person who is the recipient of the spousal support wants to maintain the household, and they'll be able to do it with the income that they're receiving from the spousal support. The problem with those types of cases are that the bank and a lot of the financial institutions want to see a long-term commitment for the spousal support, and they want to see that the payments are being made for a substantial period of time before they'll even consider refinancing for the spouse who's receiving the spousal support. So in those types of situations, it's almost like you need to get even longer to allow the party to do the refinance, because until they can show a track record of receiving a certain amount of funds for an extended period of time, they won't consider that to be their income, even though they're court ordered to pay it. They want to see that paper trail for quite some time. And one of those gotchas that you kind of were talking about earlier is that there can be an agreement for the spouse that is paying the spousal support to pay directly to a third party. So for example, they could pay the mortgage company directly to ensure that their credit is being protected, and also to provide the spousal support to the recipient. That does not do any good for the person receiving the money as far as the financing is concerned. They don't get credit for that payment being made, because they're not the ones physically making the payment. So that is something that is a little bit trickier. And it is important to try to look at your party that you're representing in your divorce a few years out. How is this going to play out for you? What types of things can we do to make sure that you'll be able to refinance? Sometimes we write the language in to say every 6 months they have to try to refinance, or every certain amount of time. But ultimately, a lot of the times the language in the judgment of divorce says if you cannot refinance, the property is sold. So that tends to be kind of the bottom line. And sometimes the parties work it out, and sometimes they go back to court and hash it out later. But it is a bit tricky, and it's hard sometimes to convince other family law attorneys that don't handle or deal with any sort of bankruptcy, because they just don't understand the complications that come with it.
And Amy, you could reverse that, I would think too. Maybe the party who's paying the support in this instance is keeping the house, but they've got to refinance within a certain period of time. And when they go to refinance, they've got this additional expense of child support and alimony, which is beyond what the bank will allow them, because it eats up a certain percentage of their income. And now they're stuck. They can't refinance themselves because they have too much going out. Same kind of problem, I would think. I mean, it's just, that's why I don't do divorces.
It definitely can be tricky. And that's why we're having these conversations, because people will often go into a divorce or into a bankruptcy and needing both things. And they don't always have the foresight to look at some of these issues. And then it's just very complicated later on to sort it out if you don't know the questions to ask ahead of time. And so, I really appreciate both of you coming on today to sort this out for people and help give that information. Now, is there anything that came up during the interview that you'd like to mention at this point that we may have missed?
I've got one minor thing, and it doesn't usually come up, but if we're going to get through everything, let's just mention it. We talked about how a lot of times assets are transferred in divorces through the divorce judgment. If you're contemplating bankruptcy and you're going to do the divorce first, I would strongly suggest allowing the transfer of the asset to happen through the divorce mechanism versus trying to transfer the assets ahead of the divorce. Because when you transfer assets without receiving certain value, it can trigger a real big problem, a fraud problem in a subsequent bankruptcy. Whereas if the divorce mechanism, the judgment, does the transferring through that negotiation, you don't have that same issue. And again, my big topic is, again, consult with the bankruptcy attorney, consult with the divorce attorney, because we'll tell you that. But you generally want to, don't go jump off and do something on your own. Get the advice of counsel and follow the protocol.
Yeah, I mean, absolutely. And we talk about this a lot on these interviews. I mean, we Tim and I get together every week to talk about topics in bankruptcy law. And so many people think that they can just get a form online and do it on their own, and they'll save thousands of dollars. But, let me tell you, you could be costing yourself tens of thousands, maybe hundreds of thousands of dollars later on, depending on the situation. And I believe the same thing goes for divorce, because, I definitely know people that have gotten divorced without an attorney, and, sometimes they even brag about how, uncontentious it was. Oh, we went to lunch after, and we were just friends. And then, later on, they're down the line, and they can't afford to help their children because they really didn't get the child support that they needed, or they find out that there was a hidden asset. And there's just a lot of different things that you need to do. So if you're going to be doing anything as serious as bankruptcy or divorce, you should look at this as a very big deal, and that you want every single thing considered, and you want somebody that goes to court every single day handling these issues and who understands, just like Tim and Amy do in their respective legal aspects. So definitely get an attorney. Do either of you have anything else to say about that? I'm very passionate about that topic.
We appreciate that, Erica, for sure. I was just going to add that I really do back up Tim's suggestion to consult, because if you have a contentious divorce and you follow his advice of handle that asset transfer before you file for divorce, I think that that's a great tip. But if you hate each other and don't trust each other, you're not going to be inclined to say, oh, sure, you can have that asset, let's transfer it, to make sure that it's sorted out before we deal with the bankruptcy side of things. So when everybody can get along, things work a lot easier. But I definitely think it's worth a call. There's certainly, I mean, I'm happy to answer a question. I offer a free consult myself. And I think it's really beneficial to ask the questions before you make the move, because you may make the exact opposite move that you should be making. And a quick phone call and just some quick advice could really save you a lot of headache. And sometimes you can't just undo what you just did. So it's important to know what you're doing. And that's why we have lawyers, and that's why we have clients, because we need to advise each other. So
absolutely.
Yeah, don't be penny wise and pound foolish. You should always consult with a lawyer. And if you're going to do something on your own, if you're going to file your own bankruptcy, I'm not going to stop you. If you're going to file your own divorce and go without counsel, Amy's not going to stop you either. But as she just said, she offers free consultations. So do we. At least get the information and get the advice before you jump off. 99 times out of 100, if you do that, you're going to decide to hire a lawyer, because you're going to realize the potential complexity of the situation and how much more damage you can do by proceeding on your own, either way, with a divorce or a bankruptcy, than you are actually saving money. I have clients come to me all the time who tried to do a bankruptcy case pro se without an attorney. And usually I have to charge more than I would had they come to me in the first place, because I don't just have to do their bankruptcy case, but I have to undo what they did already and negotiate with the trustee, sometimes dismiss and refile. It just creates a whole host of problems that you didn't have at the outset. Even a simple bankruptcy it doesn't take much to set it off course. It goes way off course quickly. And I imagine a divorce gets even worse than that. So just get the consultation, talk to the attorney, figure out how complicated your situation is, and then you can at least weigh your options after that.
And the last thing that I would like to mention is that in both bankruptcy and in divorce, there is a degree of feeling guilty or shameful about what's happening and embarrassed. And, I just want to say, like, if you've never seen an attorney before, or, because you've never had a reason to, maybe your only idea of what happens is, a story that you heard about someone else that had to file for bankruptcy or divorce and what happened to them, or maybe what you saw on TV. I mean, it's very easy to come up with, how you feel about this without knowing the facts. And so, honestly, like, when you come in and work with these individuals, both Tim, I've known Tim for years, and, his law firm, everyone there is very empathetic and amazing. And I am just meeting Amy now, but I will say that Tim has known Amy for years and can say the same thing about her, and just really caring about the client. And there's no judgment at all when you come in. I mean, bad things happen to good people, and what they're both here to do is really to help you out of a bad situation and give you a new start. With both bankruptcy and divorce, that can happen. And those sleepless nights and the worries that you have, and maybe even failing health as a result of having so much stress on you for so many years, that can all go away if you get the right help and you make the right decisions. And no one's going to force you to make a decision, or judge you, but they will give you the pros and cons and give you some options, which, often the relief that comes with having options where you didn't think there were any is life-changing in itself. So take that first step. And I will let you guys comment on this, but yeah, I did want to express how important it is that you're working with somebody that you trust and that doesn't judge you. And I feel like you are both in your fields because you care.
Let me go first. I've worked with Amy in the past for a number of years. I've seen her in court. I've seen her in consults. I've talked to her about her cases. She takes her stuff home and to bed with her. She doesn't let go of it. You are always on her mind if you're her client. She genuinely cares. I think she gives too much time, and that's just the way she is. She's such an honest and good person. And she's not fun to be on the other side of a case from. So you definitely want Amy to be in your corner because she's not going to give up. She's just going to consult about your problem with other attorneys in her firm. If anyone who will give her the edge for her client, she'll take that edge, and she'll work harder than any other divorce attorney out there that I know. That's why whenever I have a divorce issue, she's the number I give out. I don't give people a choice. I give them Amy Ruby's number, and then we walk away. That's it.
That was really nice. I certainly appreciate that, Tim. I had the pleasure of working with Tim and Peggy for several years at my old firm, and I was really delighted to be asked to be a part of this interview. And we have had lots of consultations about bankruptcies and divorces where, in theory, we shared clients because of the situations that we've had, and we've had a number of cases where we just contacted each other and said, hey, I have this really bizarre situation. We've even discussed things that were not divorce or bankruptcy related and just said, hey, we have this really crazy case. Let's just bounce an idea off of each other. So I certainly appreciate that I can go into their firm and just shoot the breeze, call up Peggy. I send her an email about something. She's always very quick to respond. And it's really great to have such a really strong network of other attorneys and to be able to call them at any time. And I know that I could call them about something that had nothing to do with anything related to divorce or bankruptcy or even law, and I would get an answer and be able to have a conversation with them. So that's really great. I certainly appreciate that.
So there's love all around here today.
Yeah.
and I just want to encourage you that if you have any questions on divorce or bankruptcy or both, we do have the contact information for everyone on this video. And I just want to thank you guys so much for joining us today. This has been very informative and I think life-changing for people that are going through these situations together, because makes both of these situations can be very complicated, and when you add divorce and bankruptcy together, it just maybe multiplies everything by 10. So thank you for making it easy. Really appreciate your being on the show, and hope to have you on again soon.
Thank you.
Thank you.
All right. Thanks for watching, everyone. We'll see you soon and have a great day.